Hi, everyone. Thank you for joining us today. We'll give it a minute for everyone to get in. Okay, the rest of you are coming in. I want to thank you all for joining us today on this Tuesday afternoon. I appreciate you taking the time out of your day to come to our Civility Matters program. We have great speakers today and a great presentation. You will get your materials, an evaluation form, and your attendance certificate via email from me in about a week or so, so keep an eye out for that. And let's see, I wanted to talk about a couple upcoming events we have. One is Family Fun Day, which is on August 24th, Saturday at Concord Community Park. We're going to have bounce house, a petting zoo, face painting, really great family event for the kiddos. So I hope to see some of you there for that. And then on August 29th in Orinda at the fourth Boar, we're having a social with members of the Minority Bar Coalition. So we're partnering with the Queen's Bench, ACTLA, La Raza, multiple members. Oh, let's see. Oh, I think that's it actually. So yeah, East Bay La Raza Lawyers Association, Queen's Bench, and Alameda Contra Costa Charles Lawyer Association were all partnering together for a minority bar mixer in Orinda. So I hope to see a bunch of you there. That's going to be a great event. Tickets are limited, so sign up while you can. That's it for me. I'm going to turn it over to Commissioner Lifter, who presides over Department 54, and I will let you take it over. Thank you so much.
All right, thank you. And let me just ask really quickly, can everybody see the presentation?
It's not in presentation mode, so go to from beginning on the left. There you go. Perfect.
All right, thank you. All right, so welcome everyone to the Civility Matters program. This is a presentation by ABOTA members and Judge Bowen in conjunction with the Contra Costa County Bar Association. The intent of the program is to provide education that satisfies the new requirement for education in civility. Our panelists include Judge Christopher Bowen, who presides in Department 40 in Martinez, currently a criminal assignment. He is also the assistant presiding judge, and next year will be the presiding judge. Our defense attorney from ABOTA membership is Wilma Gray with the McNamara firm. Wilma has been an ABOTA member for more years than I can count, and including a past president. She has done a number of presentations as an excellent trial attorney, and we welcome her to the panel along with Andy Schwartz, Casper, Meadows, and Schwartz. And Andy is a plaintiff attorney, also an ABOTA member for many, many years. And with that, I will turn it over first to Andy.
Thank you, Commissioner Lifter. Why do we have this program? It's for a million different reasons. Most importantly, I think it just makes you a better lawyer. It makes you a better person. You feel better about your job. There's so many things. There's so many things out there about our profession that isn't good. And these kind of programs, we're trying to take the lead to teach people that you're an advocate, you're working for your clients, but civility is important. You're a professional. You need to be a professional. You need to stay professional. And when you first start out in this job, at least for me, when I first started out, being civil in some ways was counterproductive. And it was counterintuitive rather. And you were ready to do battle. And you could be a zealous advocate and you could also be civil at the same time. The two aren't mutually exclusive. The American Inns of Court, what we see now on the latest slide, where I think a number of you were members, and I was a member of the Robert McGrath Inn of Court of Contra Costa County. It was an honor to be a lawyer, and I was proud of the fact that I passed the bar, and I was starting off as a public defender in Contra Costa County. And nowadays, there are local rules, and we're going to see some of those. There's a California rules of court, and there was a host of appellate court opinions that talk about how important being civil is. And just because you're a zealous advocate doesn't mean you shouldn't maintain some civility during the course of your litigating the case against your opponent. Commissioner, do you want to turn over to the next slide? Always remember that the practice of law is first and foremost a profession. It's terribly important that you remember that. You're there representing a client, but you're also a professional. You're not in a street fight. There are rules and there are ethics that you must follow. Here we have the California Rule of Court 9.7. The oath to be taken by every person on a mission to practice the law is to conclude with the following. As an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. And that's relatively new. It's only 10 years old. And there are professions evolving. And it's evolving in part, at least, because it devolved into some things that weren't good. We're going to make reference to this later on in this program, but you know, a lot of people watch Judge Judy and they think that that's what our profession should be about, and it is about, and it's not the case. I mean, I look for myself personally that I started in this profession and I've learned a lot, and I've made a lot of friends, and a lot of the friends that I've made are my opponents. I've been a member of ABOTA, I don't even know how long, 20 years or so, and there's a lot of people in ABOTA who are on the other side who I've litigated cases against. And yet we're friends, we're friendly, we're courteous with each other. And I think it's important that you learn that even though you're representing your client, there's no reason to be uncivil at any time during the course of the litigation. And we're going to go through examples throughout this program of situations where you're given a choice to be courteous, to proceed with integrity, and still maintain your advocacy on behalf of your client. You see here we have California State Bar Rule 2.72 that requires now, as of January of this year, that at least 1 hour of education addressing civility in the legal profession. I've been giving these lectures for years now, and it's never been required, but it's always been well received. I think it's important that people understand that zealous advocacy and representing your client doesn't necessarily include incivility. It's important, I think, that we all learn that we're all in this together. And I know I'm going to repeat myself throughout this hour, but it always takes two. If there's someone on the other side who's not treating you the way you should be treated, don't return the conduct. Try to stay above the fray, and that will usually lower the temperature in the room, in the deposition, in the litigation. And if you take the lead and continue to follow the rules and remember that this is a profession that you're in, it's not a street fight, the temperature will often be lowered just by that conduct in and of itself. You can see here we have Commissioner Lifter's put up here the proposed new rule 8.4.2 prohibiting incivility. I can't speak to when this is going to be enacted, but the people who are running our profession feel that this is important. Unfortunately, a few bad apples can spoil the bunch. My personal experience is, you know, it's rare that I've had a problem with this, but it does happen. And like I said, it takes two. And if you take it upon yourself to lower the temperature in the room, to bring the discourse down to a professional level, it often works. I've been doing this for a long time, and you can avoid a lot of problems for yourself, a lot of problems for your client, and in some cases, a lot of problems for your case if you maintain a professional demeanor, act appropriately, and maintain the civility that's necessary to proceed with the litigation.
All right, so Andy, why don't you show us some examples of incivility?
Right, well, right, here we go. This is a, I can't read the bottom of this. Is that on purpose?
Let's see what's going on here.
I've got my copy and it's the same. Yeah, here's a communication that was sent by someone to someone else, obviously. I don't know exactly when. This is what you shouldn't do. I mean, I don't know if I need to read this, Commissioner Lifter, or is it going to be read?
No, you don't need to read it. I think it's perfectly fine that everybody can just take a look at it. I'm not sure what the problem is with the slide at the moment.
Yeah, that's all right.
It was working perfectly well when we went through it yesterday.
Right. By the way, that, do you want to go back to that for half a second?
Sorry, we're going. There we go.
Yeah, this is the kind of thing that you shouldn't do. And we're gonna deal later in the program where we're gonna talk about what you do when you get an email like this. But don't send these, and when you get them, don't respond to them in kind. That's all I could say. I'm curious, and from the panel, from the people who are in the audience, if they get a lot of these. I didn't. You want me to read it since it's cut off? I can only read what I see, unfortunately, Maria. But let me just say, using expletives in emails is counterproductive. It's not going to help your case. It's not going to move the ball forward. It's not going to help your client. I've used it. You can change the slide now, Commissioner Lifter.
No, I'm sorry. I'm not sure what the issue is here. I apologize, but go ahead.
Yeah. Well, on the next slide talks about the word zealous, and I've used it a number of times. In my speaking this morning, I mean, look at the word impassioned, devout, devoted, committed, dedicated, enthusiastic. That's fine. Avid and vigorous, energetic. Those are all important attributes to a real good lawyer and a real good advocate. But zealous advocate doesn't mean jackass or incivil or uncivil. It takes a little bit of nuance to do both, but once you get in the swing of it, you could do it, and it becomes second nature. I remember when I first started out, how concerned I was that I wasn't going to be pushed around. And I might have behaved inappropriately at times, but live and learn. As I moved on through the profession, and it's been a number of years now, you learn that treating your opponent as another professional, you'll make friends. You'll be more effective advocate. I tell people, never tell anybody you're gonna beat them up or you're gonna take them out. You have a courtroom to do that, and you could do it in a civil and a confident way, and no personal attacks. Don't be disagreeable. I tell every young lawyer that I ever speak to about trying a case, I guarantee you, and there are a lot of trial lawyers in this group and on this panel, that if you're in trial on any kind of case, you're going to need a favor from your opponent at some point during that trial. And developing a relationship with your opponent through the course of the litigation. In some litigations, there's 30, 40 depositions. I had one case, I think I took 63 depositions in 7 states before the case finally came to trial. You get to know each other. You get to know each other well, and you see each other in all kinds of situations. And I promise you, in state court and in federal court, you're going to need to call upon your opponent to, you're going to ask a favor of that person. And you're not being civil just because of that reason. But it sure makes asking for a favor a lot easier if you have a relationship with your opponent. And being a zealous advocate and being friendly or not inconsistent with one another.
Andy, if you don't mind, I'd like to just weigh in as the defense counsel. I would say ditto. I agree with everything that Andy has just said to you. And as you can see, it's the ABOTA professional requirements. It's the California State Bar. It's the local rules. It's the proposed new rule 8.4.2. I am shocked that we need a new rule that says prohibited incivility. What has our profession come to that we need to actually have a new rule? But obviously we do, and I'm very proud that the California State Bar is setting forth the proposed language for a new rule. I think, as you've pointed out several times, Andy, we can be advocates, we can be zealous advocates representing our clients, but we do not need to be uncivil with one another. I just want to point out, you mentioned the oath has been in effect with the civility language in it in the state of California. I can tell you from having served on the as a national board rep for the San Francisco chapter of ABOTA, that our group in California worked with the California Chief Justice to change the oath for new attorneys. In 2014, we were one of the first states across the country, and we are now, little by little, each state is adopting new language, which includes civility, professionalism in the oath. And we're talking about changing that to have experienced attorneys like Andy, like myself, retake the oath to remind all of us. We've been here for years, but we all need reminders to be civil and professional. So I just wanted to add that, Andy. Thank you.
All right, and speaking of the deposition setting, let's take a look at this.
So, Fred, once again, and I say this with all due respect, you are one of the most ignorant people I've met in a long time. And your comments about this are ridiculous. Then leave.
This is really not. I mean, you're trying to take advantage of the fact that she's upset by continuing to argue.
No, Fred, what I'm trying to tell you is that you're being a jerk, and that you're being an idiot and a jerk, and you've been this way the last two depositions. And I would really respectfully ask you to just sit there and be quiet and make appropriate objections, if you're going to make any at all, without making a speaking objection. Now, if you want to get on with this deposition, please do. But in the future, don't interrupt me with meritless comments.
I think you're the one that needs to get on with the deposition.
Sit down, Fred. Sit down or get out.
Why don't you get out?
You got it, Fred.
Go in the hallway?
And then do what? What are you going to do in the hallway with me, Fred? What adult, mature thing?
What are you going to do?
I'm going to walk out of here. What adult, mature thing are you going to do in the hallway, Fred? Huh?
What are you going to do?
I didn't ask you to go in the hallway. Why are you standing up? What are you doing, Fred?
What are you doing?
You're, again, seriously, your true strengths are coming out.
For the witness?
Sit down and shut up.
All right, so Andy, any of your depositions go like that?
Not recently, no, but it never is a good idea to challenge your opponent to a fight in the depositions, particularly when it's being recorded and videotaped. But they don't go like that. Don't take the bait. I mean, I don't know what went on with these two guys, and this was when 2000, what does that say, 16 or 18? I can't even read it. But whatever went on between these two lawyers obviously hit a boiling point during the course of the deposition. And the poor woman who's sitting there is listening to all this, and she's going to have a heck of an impression of the legal profession after she's done with having her deposition taken. Be that as it may, I've never been involved in something like that, nor have I ever seen anything like that. And like I said, I've taken a lot of depositions and I've done a lot of trials, but it happens. And I think that, like I said, one bad apple can really spoil the bunch. And I have people who are non-lawyers talk to me about the legal profession. And all they talk about is the OJ verdict and the Dan White verdict. And they think that that's how we operate. And it's just not the case. I mean, I've been in this profession since 1975. And then some of my best friends I've made through litigating cases against them. It doesn't have to turn out that way. And it's the right thing to do, and you're a better person for it, and your life is more fulfilled for it. But like I said, it often takes two.
How about you, Wilma? Have you experienced anything along the lines that we saw in this video?
Wilma, you're on mute.
Only one time have I experienced it where one attorney chose to demonstrate bad behavior, make a record of it, and all of the other attorneys in the room, plaintiffs' attorneys and defense attorneys, did not engage. And that was really the way to solve the problem. And that excerpt of the videotape deposition is now an exemplar for a Civility Matters program. So the next one you attend may have that particular videotaped deposition. But that's been my only experience, and I can say, and I personally watch this, and I feel so sorry for the witness, because the attorneys have just made it all about them, not about the witness. It's not productive. And I saw Angel from my office just comment, what a waste of time for the attorneys to be battling back and forth between each other. If they want to meet and confer, go off the record, meet and confer, and just, but be professional, especially with your client, the court reporter, and understand that this is going to be an exhibit that perhaps Judge Bowen or Commissioner Lifter might get the the opportunity to rule upon what was right. But they both took the bait, and they both ended up being unprofessional. So I think that is the extent of my comments on that bad behavior.
Well, Wilma, let me say one other thing though. But I used to tell people that I litigated more cases against your firm than any other one firm.
That's probably true.
And it's never been an issue. So what you're doing at your firm is working, and hopefully what we're doing in our firm is working too.
Yeah.
We've all been in this county for a long time. And it's important that we take the lead in this, because I don't see it as a major problem from my personal experiences, but reading all that I'm reading and hearing all that I'm hearing, it obviously it is. And all we could do is be out there trying to express to people that you're not unsuccessful if you're civil. I had a great run, and it wasn't from being a jerk. I think being a jerk is counterproductive, and it's not going to get you where you want to be. And
well, it's something that I've observed is that it costs more to be uncivil, because all of a sudden you're in motions, you're appearing in court, you are most likely going to be sanctioned. There could be attorney's fees against you. And as Andy pointed out, my firm, his firm, have been opposite sides of cases for many, many years. And I don't want to have a bad reputation in this community, because I am going to be seeing not just the same judges, but the same attorneys time and time and time again. And I don't want a negative impression in the community generally about lawyers and our profession.
yeah, I'll let Judge Bowen and Judge Lifter comment on this. I don't know if they hear a lot of that in their courtrooms.
Certainly nothing like what we saw in the depot.
Yeah.
Not in court, but on my calendar, it's a lot of self-represented litigants, and there is some rather colorful language in the courtroom on almost every day.
Right.
But not from the attorneys.
Good.
So that leads us to this question: is lack of civility a problem? And we'll ask Judge Bowen, what do you think?
Well, I think that it operates on two levels, and one sort of jumping off from where Wilma and Andy said, you know, I think that we're very fortunate in our legal community and in this county generally to have a very high and very civil standard of practice on the bar. I don't have personal experience in the civil context, but I do have extensive experience from my 5-year foray into family law, 5 very good years, I should say, wonderful years, where I met a lot of lawyers, virtually all of whom were civil and professional. And one thing I was thinking about is, you know, what advances the legitimate goals of your client? Legitimate goals. Now, if your client's goal is to drag things out forever and make it as painful as possible, that's not a legitimate goal. But does this kind of behavior, does that kind of behavior, for instance, in deposition, advance? Oh, I'm going to cry now. I see a very nice comment. Thank you. I miss you too. All right. So does that, and does dragging things out or being unnecessarily caustic advance the legitimate goals of your client? And I agree with Wilma. It probably just costs more money, certainly makes things take longer. I can tell you, judges don't like it. And when you're doing jury trials, juries really don't like it. But that's only one part of the answer to is lack of civility a problem. Then let's talk about the wider world. And we've got apparently a problem. This is a really great case that summarizes several other cases. So it's a 2019 case out of the 1st district, pretty sure. Yeah, no, sorry. This one's the 4th district. They summarize about 7 other cases, mostly from California, 1 from another state, and then they go on to say that courts have had to urge counsel to turn down the heat on their litigation zeitgeist far too often. And while the factual scenarios of these cases differ, they are all variations on a theme of incivility that the bench has been decrying for decades with very little success. This was a case where there had been a really legitimate motion to set aside a default. Ultimately, the appellate court ruled that the trial court should have granted the set aside, that it was an abuse of discretion not to. There were actually real reasons to grant it, including virtually no discernible prejudice to the other side, it having been made extremely promptly after the default was taken, and actually a meritorious defense. So you know what, there's something that we didn't put up on the slide, but that is mentioned later on in the opinion, which I thought kind of is a nice way of keying back into, we've incorporated some of the ideals of the Inns of Court. So they quoted from Chief Justice Berger, and he was one of the people that was instrumental in starting the Inns of Court movement. And at the very end of the LaSalle versus Vogel opinion, they quoted from Chief Justice Berger. It says, "Lawyers who know how to think but have not learned how to behave are a menace and a liability to the administration of justice. The necessity for civility is relevant to lawyers because they are the living exemplars and thus teachers every day, in every case, and in every court. And their worst conduct will be emulated perhaps more readily than their best." So anyway, that's a really good case, especially since it contains sort of a survey of appellate cases that have talked about the problem from the appellate court standpoint of incivility. Now we're moving on to LaSalle versus Vogel. Surprise, surprise, it's another set-aside default case. Oh, actually, you know what?
Nope.
Oh, wait, we've moved on. Sorry, I just did that one.
I'm sorry. Yes, thank you.
Now we're on to Kim versus Westmore. Surprise, surprise. It's another default judgment case. And in that one, the court found that the trial judge that there were several problems. One was the trial judge had too hastily and sort of summarily denied the default. The second one was the trial counsel. And then the third one was appellate counsel. So there were problems all like sown throughout this case. And so this is a little bit older than the previous one, but I'll just, the bolded portion there, the appellate court said it's time to stop talking about the problem and act on it. For decades, our profession has given lip service to civility. All we have gotten from it is tired lips. All right. So then kind of in practical context, we talk about requests for extensions of time. I did deal with this not infrequently in family law, especially with respect to discovery, or it can also happen in the motions context. And the California Attorney General has actually issued guidelines for civility and professionalism. And this one essentially encourages counsel to be reasonable in considering a request for extension of time. I mean, I think that probably a good rule of thumb, of course, always the client's best interest is foremost, but really, I think that most extensions of time probably ought to be granted. I just think that's true. I think that if you're in a situation where you're never agreeing to an extension of time, you might want to just, have a check-in with yourself and see, are you being obstreperous or are you being difficult? I mean,
Let me jump in.
sorry, are you being
Judge
reasonable?
Bowen, can I jump in for a quick second?
Yeah, I want you to.
Yeah, like I said, I've been litigating these counties for almost 50 years now. It's never in your client's best interest to be a jerk. And to your point, Judge Bowen, if someone needs more time, they should have it. You don't want to be walked over, and you won't be walked over. No one's ever accused me of being someone who's walked over. But if someone needs 30 days to answer interrogatories or 30 days to file an answer or things like that, it should be like Judge Bowen says, it should be a rule that it should be granted. You're going to need it too one day, but that's neither here nor there. People are busy, deadlines are deadlines, and they can be extended for the most part. So I'll totally concur with what Judge Bowen said. It should be a rule that extensions of time should be well, there we go. Thank you for the slide, Judge Lifter.
And so this kind of summarizes what Andy and I were just saying, that civility should be the norm. That, attorneys can't let clients drive the bus. And if the clients are asking an attorney to engage in abusive conduct, the attorney has to say no. That's not furthering the client's interest, just to be obstreperous and make things painful for everyone.
Right, and also I'll just add that even if it were furthering the client's interest, you can't do something that's contrary to the rules that govern us in our profession or govern you in your profession, because there are rules that apply to judicial officers as well, just because it's in the client's interest, because you're violating your duty. So.
And we have an obligation
This one was
to our clients.
Sorry, Wilma, I didn't hear that.
We have an obligation to explain that to our clients and explain that we are not giving anything up by granting an extension, or that we have rules of professional conduct that we are held to.
And I think this slide illustrates what Andy was saying earlier.
Yeah, this is a Ninth Circuit case where there was a completely reasonable request for an extension of time to file a reply to a motion for summary judgment. I think it was like 3 days that they were asking for, and it was not agreed to by opposing counsel. The court denied an ex parte request for the late file, and that was reversed on appeal, and they mentioned the golden rule. They found that the trial judge had unreasonably denied what was a very reasonable request to file the reply 3 days late. And then as a result of that, the summary judgment ended up getting entered. So We also, oh, I'm sorry.
Oh, I'm sorry, go ahead.
I was gonna say, we have incorporated into our local rules of court, the Contra Costa County Bar Association Standards of Professional Courtesy. So those are actually part of our local rules and enforceable, as part of the rules of court. And I suppose the corollary is that, a violation of the local rule is subject to some type of corrective sanction. So I won't read the whole thing, but you can take a look at the local rule 2.91, or you can visit the Contra Costa County Bar Association's website, and the standards of professional courtesy are there.
And in addition, those standards of professional courtesy are part of the materials that are being provided in conjunction with this program.
You know, and if you play this all out, Judge Bowen, you could see if you deny it, if you deny a request for an extension, and if your opponent's got to go to court to get one, the judge is going to see what you did, and it's going to hurt your client. So while your client might think in the short term he's doing something good, you're doing something good for your client. In the long term, you're defeating the whole purpose of what you're doing, which is representing this person and trying to succeed in court. So once again, we're being repetitive to some degree, but these rules are here for a reason. And on so many different levels, it's important to exercise civility and courtesy.
And so back to the issue of civility and depositions, and we'll tee this up to Wilma. What do you do at a deposition if your opponent improperly objects, coaches the witness, or insults your client?
Wilma, you're muted.
We saw an example earlier of that, but it happens to all of us. And the question is, how do you? So let me invite Andy to read the plaintiff's counsel, and I'll read the script for the defense counsel, just so that everyone gets the gist of this.
All right. Wilma, we've sent you offers to settle. You've dragged us through this nonsense. You've been sanctioned $6,000, and yet you keep this nonsense up. Now I'll take a lunch break, and based on your little preface a minute ago, I'll go through with my client various paragraphs so we can come back in here and answer your questions. We are now at lunch.
Okay, fine, Mr. Schwartz. I would appreciate if you maintain your professional.
I cannot, because you're an idiot.
Mr. Schwartz, I share that view of you based on your statements here today.
6,000 sanctions for your nonsense of wasting my client's time because you or someone in your stupid company.
An attorney is entitled to that testimony. I don't know where you went to law school.
Wilma, pay your damn sanctions. And if it was up to me, I would have added an expletive in there, but I didn't.
So obviously we've heard some form of this in the past. The mistake on the defense attorney side was not keeping it professional after line 14. So what do we gain by calling the other side an idiot or using statements such as this? We've just escalated it to then file a motion. We've got a video from Paramount Communication Inc. And some lessons learned on how to make a record.
At all times together. That's what this is.
All right, can we discuss this another time?
I ask you to go off record. You don't want to straighten it out. You don't want to understand. You don't want to save us the time. You don't want to understand. This is all been examined.
So
this has all been examined with other witnesses.
So why don't you just tell me what the case is, and then I won't defend anybody. How about that?
No, you defend it more efficiently if you understood what had happened before.
This on the record. I don't need your lectures. So knock it off.
I'm just responding to your question.
I didn't ask you a question.
If you look at
Counsel, I'm not doing this.
ask about
Counsel,
442.
Stop it. You want to do this?
Or you could check with the deposition from Tim Zion, where he went through all of this and explained all the problem with the Johnson switchgear, why they were the origin of the transients, and how they were killing the surge arresters, and how it was solved by the Siemens gear and the pre-insertion resistors.
You don't get to have a dialogue.
Okay, I thought I was responding to your question.
No, you don't. Should we take a tape of this and bring this to Judge Seymour and see how she likes your monologues?
No,
I don't think she will.
no, I'm simply responding to
I
your
didn't ask you a
inquiry.
question.
So another example in deposition of essentially a waste of time, the colloquy between the two attorneys. They're not advancing the goals of their clients. trying to make a record, but not, I feel sorry for the court reporter and the witness. The witness sees this waste of time, sees the unprofessionalism. The court reporter can't take down everything. They're talking over one another. But more importantly, as don't take the bait, be professional, and you will be a much better zealous advocate for your client. So conduct in the deposition, ABOTA professional principles. Your conduct in a deposition should be the same as if you were before a judge. None of us would appear before Judge Bowen or Commissioner Lifter and behave like those two men did. First of all, there'd be a referee in the room to stop it. But imagine that every time you go into deposition, you've got a record. There is a referee in the room. If not that day, then later down the road. So just words to think of and to remind your opposing counsel or other attorneys in the room of.
And let me also add, if you know you're gonna have a situation where there's gonna be one of these bad apples out there, it's all the reason to videotape a deposition, because then you'll have it there. It says, Wilma said, the court reporter is not gonna get everything down. And if your opponent is behaving like a jerk, and you think it's gonna happen because it's happened in the past in the case, it's all the more reason to videotape the deposition. We reached the point in our firm where we videotape most depots. I don't know if that's the general practice of most people in the audience here today, but if you know you're going to have a potential problem, it's always a good idea to put it on videotape so you don't have to describe it. It speaks for itself.
You also have the option of seeking leave of the court to appoint a discovery referee, or just informally agreeing if you know you've had a history of problems in depositions. Ask for a discovery referee. It can be a retired judge, a senior attorney, who you pay to sit through the depositions and rule upon objections and to control the situation. So those are two options of dealing with it.
Yeah, and it's a recoverable cost too.
All right, any tips for what to do if your client is uncivil to your opponent during a deposition?
Yeah, that's simple. If that happens, you stop the deposition, you take your client outside and you speak to your client. We used to call it woodshedding.
All right, how about what do you do if you receive argumentative, nasty emails, letters, or voicemails from your opponent?
Well, you take a deep breath and then maybe you type the email and then you don't send it. Here's an example. You want me to read this, or can let everyone read them themselves? I hate your effing existence. What you did to my property was vicious attack against the sumac cover planted by Irene Polson. I mean, you're going to get these, and it's important that you, like we've said this over and over again, don't take the bait. It takes two. And don't be silly enough to put these vile thoughts in writing to begin with. I mean, it's the new world we live in. Everything's lasts forever. You say, well, I mean, people have tweets that they sent 10 years ago that are ruining political careers. I mean, it goes on and on.
Yes.
Don't hit send. I mean, it's a real simple answer. I mean, go to your office mate and vent, and call your partner and vent.
Yeah.
Punch the wall, and there's a million things you could do, but the last thing you want to do is respond to this kind of stuff. Maybe you keep it somewhere where you can for the judge to see at some point during the course of your case. But if your client is abusive, that's unacceptable. It reflects on you. As Wilma said earlier in this program, it's up to you to tell your client what's expected of your client. When I was doing a lot of litigating, I was involved in very emotional cases where death of loved ones were involved a number of times. The emotion runs high in those cases. But believe me, it's not hard to keep the temperature down and just be a professional and do what you have to do to get through it, quite frankly, because some of it isn't very easy and it's gut-wrenching sometimes. But incivility is not a reason to, it's not a place where you really need to go. This DeRose versus Herlin opinion, I mean, there you go. It's you send these letters and they shows up in the published opinion. And that's there forever for every member of the bar and every judge to read. it's another lesson learned for this lawyer who may or may not have learned a lesson. But you should learn a lesson from what this lawyer did by mistake. Don't behave that way. There are more and more appellate court opinions coming out sanctioning lawyers or adverse ruling against cases where the sole reason is incivility. And you don't want to be one of the poster children for that.
No, and what can happen?
Yeah, you can get sanctioned. It's amazing. I see a question. You want to answer it or do you want to wait to the end, Commissioner Lifter?
I'm sorry, if you're ready to answer the question, you can. Otherwise, we do have time, we
All right,
hope,
well,
at the end for
let's
questions.
wait to the end. I'll be happy to answer the question. Let's wait to the end. You know, this Code of Civil Procedure in the Civil Code, surprisingly to me at least, doesn't shy away from recommending sanctions. You don't see it a lot. I didn't see it a lot in my practice, but where I've been headed lately, I see lawyers' behaviors that almost require sanctions. And with the case law building the way it is and with the rules of court expanding, if you behave inappropriately, it's going to cost you money, it's going to cost your client money. That's going to cost you money and cost your client money, it's going to cost you future business. And it's no way to proceed regardless of the fact that you could be sanctioned. But this is just another reason to behave appropriately during the course of your litigation.
All right, and voicemails can also be problematic, as this will demonstrate.
We got your last message. I'll tell you very bluntly, if you are intending in any way to send these emails for any purpose whatsoever other than to vent, my response to you is very simply going to be save your breath. And if you have any issue you want to speak to me, Shane, or myself about, call us and discuss them. If you send one more email like this again, I can assure you your life on this deal is going to be very unpleasant, because I'm going to get my client involved and we're going to make it very clear that you are not cooperating. So our changes are necessary. The change was addressed in a global comment to you, was that to insert our client's address. You made a change without our authorization, whether you consider it material or not. Again, I don't give a fuck. Make the change, be the middleman monkey, or give us the job to do, and we'll take care of it and we'll do it properly. Your mortgage document was sloppy. All right. We limited our comments and we made very specific comments. If you can't be a monkey tribe, then you know what? Let us do it. We'll get one of our secretaries to handle it. We got a message.
Hey, did I talk over that? I'm sorry if I did.
No, it's started to play a second time instead of advancing to the next slide. So I think, go ahead, Andy, on this one. This is the ABOTA principle that addresses that type of conduct.
Yeah, this is what Wilma was talking about. It's the golden rule repeated in a different way. That's what I've been saying all along, and it's not news. I mean, you don't have to be a jerk to win your case. I mean, there's going to be 12 jurors who ultimately going to decide what your case is worth or what the outcome should be for your case. And you're pounding your chest and you're behaving like a jackass is not going to advance the cause of your client. And I know it's redundant, but it comes up all the time in different levels of the litigation.
So let's move to the civility in the courtroom.
All right, so there were two questions. What can happen if your judge is not civil in the courtroom? And then also what can happen if you are not civil in the courtroom? So Jill referred to this earlier. We've talked about the attorney's obligations, but then we talk about the Code of Judicial Ethics that's binding on trial judge, all judges and commissioners, all bench officers in the state. And so the overriding one is that a judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, and others with whom the judge deals in an official capacity, and shall require similar conduct of lawyers and of all staff and court personnel under the judge's direction and control. So there's a lot there, which means that the judge has the responsibility to maintain good behavior by everyone in the courtroom, including the judge themselves, including the attorneys or the parties, and including staff, because the court staff is really an extension of the court. So all of those players are covered by Canon 3B4. We have some examples of where that hasn't happened. This is a fairly recent case, People versus Williams. So in People versus Williams, the trial judge at a jury trial inserted themselves into the case in a way that was really shocking. It is true that judges are allowed to ask questions, but in the context of a jury trial, you gotta wonder sometimes, is it really a good idea? But I can tell you for sure what's not a good idea is to do what the trial judge did here. So during the defense cross-examination of a prosecution expert, the trial judge inserted themselves, interrupted, interposed their own objections without an objection being made by the prosecution, would cut off the witness, so stopped the witness's answers, and then just made various disparaging comments, really sort of implying to the jury that bolstering the credibility or of this witness, and implying to the jury that the defense could have or should have gone and gotten their own witness. It was pretty extraordinary. It resulted in a published opinion, which you have here. And sorry, I lost this. And I believe also after the published opinion came out, the judge was disciplined by the Commission on Judicial Performance. One of the things that the court wrote was that the trial judge's participation in the cross-examination of the witness reflected alignment, that is, alignment with one party, the prosecution. It interrupted defense's cross-examination at least a dozen times with its own questions and sua sponte objections. In so doing, it bolstered the credibility of the witness by asking follow-up questions that appeared to minimize potential reliability problems with the witness's written report and the second examiner verification. It was a fingerprint expert, and did not allow relevant and appropriate cross-examination on the scientific reports and studies regarding errors. And then wouldn't allow the witness to answer questions. I think that's in here. In sum, we conclude the trial judge's participation in the questioning of the fingerprint expert constituted judicial misconduct. And then it was reversed. I mean, the prejudice, the error based on judicial misconduct was so great that the Court of Appeals reversed the judgment of conviction. Then separately from being kind of called out in the reported decision, the judge was disciplined. This is an interesting case, civil case. I mean, it's hard to believe. It's funny, the Court of Appeal sort of characterized it as, not intentionally disrespectful, but just kind of creating a circus-like atmosphere. This was a case where the judge had made a handmade sign that they held up when they were overruling objections. And by the way, they overruled most of the objections. And then at one point, the other party brought in a more a printed sign rather than a handwritten sign. And then there was colloquy about that. And just really, the judge was hamming it up, and one of the parties was playing right into it. So it was extraordinary. And on the second slide, the appellate court said that it wasn't malicious, but a misguided attempt to be humorous. And nevertheless, they were concerned about the effect on the jury. How did this behavior during the trial, during a very lengthy trial, so it wasn't just one instance, it was several instances throughout the trial, how did that affect the jury? And how did that affect the way they viewed the system, the court system, and the bench, and the legal profession, after the trial was over? So.
All right, if our panelists don't object, I think that we should, at this point, we have about 3 minutes left, allow for questions.
Sounds good.
That was good to me.
So do we have questions?
There are a bunch. In the
That's-
chat.
There was a question, how do you handle a situation where opposing counsel is not being civil in a setting where the judge or neutral is not correcting the bad behavior?
Does this question mean during the trial?
During a trial or a motion hearing? If it's during a trial in front of a jury, one of the things that I might think of is asking for a sidebar to then discuss either in chambers or at a sidebar, certainly outside the presence of a jury, to discuss that you would like a certain conduct to be, and you can speak directly with the opposing counsel, but also invite the judge to, at that point, maybe comment or change the behavior and deal with it. The example was an opposing counsel crying on a conference with the arbitrator. So yeah, not being able to get a word in edgewise. That's a difficult situation, and maybe needs to be addressed in a separate situation or hearing. But actual tears and crying, how do you make a person stop the tears, and how do you make an arbitrator rule upon it, unless you have some sort of evidentiary objection or some matter that you're going to have the judge rule upon, or the arbitrator?
I'll say something else. If in this hypothetical, you're in a jury trial and the judge is not correcting the behavior of your counsel that's clearly inappropriate and clearly should be corrected, part of me says Wilma's right, but another part of me says just stay out of it. Jurors are really smart.
That's true.
And they're going to see what you're seeing. And if this person on the other side of you is behaving inappropriately and the judge's not doing anything about it, in all likelihood, the jurors are going to side with you and take your side of the case. Trust your jurors, folks. They're smart people. They know what's going on. If there's someone acting a fool, they're going to know it. And if the judge isn't correcting it when they should, the jurors are going to know that too. I see all the lawyers on my panel are agreeing with me, because we all have been trial lawyers at some point in our lives. Trust the jury. They're going to do the right thing more times than not. Are there more questions?
So it looks like we have run out of time and run out of questions. So thanks to everybody for your participation.
Thank you so much, Commissioner Lifter, Judge Bowen, Andy, Wilma. It was a great program. Thank you so much. Thank you for everyone who attended. Keep an eye out for your certificates and your eval form. We'd love to get those back so we have notes for programs going forward. And I hope everyone has a great rest of their week. And thank you for the comments that are saying thank you. Yeah, great program, everyone.
Thank you, everybody.
Thank
right.
you very much to the
Thank you.
Contra at the bar and to Ms. Commissioner Lifter for putting this all together. Appreciate it.
Thanks. It was nice working with all four of you, all three of you. Thank you.
Thank you.
Bye, everyone.
Goodbye.
Thank you all.